All right, state defense. These are the questions. And these are the proposed answers for the court.
I thought this hearing is not even open. Did you have to read? Yes.
Normally, I would
Great.
ask that
Okay.
you just say you have all
Okay,
the
go on.
evidence
Okay.
before you.
No, I'm not gonna do that because they have a specific. They want testimony read back, and to say you have all the law and the evidence doesn't answer it. So I'm just telling them if they want witnesses' statement, it has to be a dispute. So this is this one. And I have two answers to that.
Yeah, I'm okay with that answer. No problem.
There's two.
Okay, sorry, yeah. The generic, this one gives the thing about the attorney's statements are not evidence.
And what I can tell both parties,
Yes.
Yes, Your Honor, I agree.
all right, so what I can tell you all, and we'll go on the record, but from my memory, I know what the jury's asking, and this is not the witness who gave that information. But what I can tell both parties, this whole transcript is not the answer to this question.
Right.
So the whole transcript is not going to be going back. The only thing that comes close to being the answer, and I don't even think it's the answer, is from page 154. And it's this answer A. Well, I happened to notice a fight in the car. You know, the front passenger was turned around and was fighting somebody in the back seat. And I didn't know who it was. And then the passenger in the back seat jumped out and screamed, helped, and was yanked back in the car. That really got my attention. So it's like, wait a minute, somebody needs help. That's the closest thing that comes to answer the question. The entire transcript is not an answer to the question. So the entire transcript is not going back.
We're agreed with that.
I don't, Your Honor, I don't think the question's specific enough based on what we've reviewed in the transcript for any of it to go back.
Oh, no, I mean, the question is very specific. We're going to go on the record. Court is calling 2019 CR 12495 State versus Taymor McIntyre. Both counsels are here. The defendant is present. The jurors say, and I'm going to take the questions in the order in which they were given. Jurors' first question. We are in disagreement of what the woman who was homeless at the time heard Mark say when trying to get back in the car. So can we have the testimony to the above? That's a specific question. She wants to know, the jury wants to know what the homeless woman at the time heard Mark say when trying to get back in the car. What the court reporter has pulled is question. Okay, and then after that, can you tell me more about the second car and why that car caught your attention? Answer. Well, I happened to notice a fight in the car. You know, the front passenger was turned around and was fighting somebody in the back seat, and I didn't know who it was. And then that passenger in the back seat jumped out and screamed, helped, and was yanked back in the car. That really got my attention. So it's like, wait a minute, somebody needs help here. That's the answer to that question. But again, the entirety of this transcript is not the answer to that question. I understand that people want context, but the court's job when a question is asked about a specific disagreement, it's not for the court to give context. It's just for the court to answer that question through the court reporter's transcript.
Yes, Your Honor, but as you yourself observed, it doesn't appear that the question that the reporter found for this witness is what they're actually disputing about, that they appear mistaken about.
No, what the court is
testimony.
saying is from the court's memory, there's another witness who gave an answer. But for this specific question, through the homeless person, this is the answer. And this is the answer from the homeless. And I hate to say, I don't want to just say homeless person, but I'm saying that because that's what's in the question. Yes.
This is excellent.
Right. So that's her answer to their question. Now, do I know that there's another witness who came to testify who said something from their perspective? Yes. But the jurors will need to ask that question and they haven't asked it. So the only question I am focused on is what has been asked here. And the court is not going to send back this entire transcript because that's context and it's not an answer to their question. So the answer to the question is as the court has read it. That's the answer. And if y'all have objections to that answer being sent back, you all can put it on the record. But what I'm telling you is the entirety of this transcript of that witness is not going to be sent back unless both parties agree that the entirety of this transcript of her testimony be sent back.
We're okay with the answer posed by the court.
And your objection would be?
We would object to just that portion going back, Your Honor. I don't believe that that answer is in direct enough response to the question that we can believe that that question is truly specific as necessary to get testimony read back to the jury. And without the entire transcript, the question out of context, I think, places undue emphasis on a very small portion of the witness's testimony, who is in and of herself just one of many witnesses similarly situated who testified in the trial. We believe that that is not what the point of the rule that allows jurors to look at transcriptions of portions of the record they dispute was designed to accomplish. What it's designed to accomplish is to really drive down to, like, was the light red or green? You know, was the answer yes or no? And this is way too vague. in
No,
the
they
grander
said they're in a
context.
disagreement as to what the homeless lady heard Mark say.
Well, I understand, but I think that it, as the court indicated, might not be what they thought it was. And I think it does place undue emphasis. And in particular, we need to keep in mind that, for one, there were two previous objections to the testimony in question elicited, one of which was sustained, one of which was overruled. So I guess for the record, we want that objection noted
Well, what I
again.
can tell you about your objection, counsel, and from reading the entirety of the record, there was no objection at that time to that question. The objection came later in the questioning, and I can tell you what page that is on. So on page 154, there was no objection to the witness's answer. Your objection came in on page 156, where it says question, okay, and then you said you heard the person in the back seat yell help. Is that correct? Answer, yes, ma'am. You objected to leading and the court sustained that. So this answer came well before that objection.
Well, and correct me, Your Honor, I don't know the order. I do know there was a second objection for hearsay that was overruled. I don't know if it came before or after.
After.
Um, my primary objection is that it places undue emphasis on a very small portion of this woman's transcript, and that out of context, it could be misleading to the jury. I don't believe the question is specific enough. We would object to any portion of the transcript going back.
All right. And so it's not when, as both parties know, you all have been attorneys, when somebody asks a specific question, when they have a specific dispute, they are not given the entirety of someone's testimony because they're not allowed the entirety of the testimony, because then there is no need to have a jury trial with people asking questions in front of a jury. You just give them the transcript to read. So in answer to that question, the court is going to either have the jury brought out, if you want the jury brought out, and I am going to read to them. Well, I happened to notice a fight in the car. You know, the front passenger was turned around and was fighting somebody in the back seat, and I didn't know who it was. And then that passenger in the back seat jumped out and screamed, helped, and was yanked back in the car. That really got my attention. So it's like, wait a minute, somebody needs help here. That's the answer to the question. So I note your objection. Your objection is overruled. The only question now is, do you all want the court reporter to print out that specific section and send it back to the jurors? Or do you want the jurors brought out and have the court read the answer?
If it's just going to be that portion, Your Honor, then it can be printed out, just the answer and just the answer sent back to them, but without waiving the objections I just made.
All right, so Cindy, with regards to that section, and I will highlight it, that's going to need to be sent back to the jurors. Could you all hand that to her? The next question that came after that, since we can't agree on whether there was a robbery or not, what is the next step in the process if we can't agree on the main charge, capital murder? Both parties had a chance to review the question.
Yes, Judge.
The court proposes the following supplemental charge with reference to your inquiry. You have all the law before you. Please continue your deliberations. Any objection?
No, your statement.
Your Honor, I think that while that language would be valid, I would suggest that, well, let me begin by saying the language of the question in its totality seems to convey that they are unable to agree as to that charge. And so we would preliminarily move for a mistrial.
All right, that's going to be denied.
And then secondarily, as to the response back to the jurors, I think that we would ask that if we could say, if you cannot agree, if you are not unanimous as to every element of capital murder, you must continue to deliberate about capital murder, because the question seems to be confused about how the charge works. And
All right,
so that's our worry.
all right, so that's going to be denied. And what the court and both of you all aware that the jury charge specifically states, you first decide on if you can come to a decision, guilty or not guilty on the capital murder. If the answer is not guilty, then you move to the lesser included offenses. Is that
That is
what
correct.
everyone else interpreted the jury charge?
Yes, Your Honor.
Yes, Judge, but our concern is that because capital murder because the capital murder portion of the charge does not have the self-defense language in it, I worry that there's confusion about how they're to consider portions of the charge that relate to self-defense as it relates to capital murder. And so by explaining to them that they have to be unanimous as to every element of capital murder before they can move to the other portions of the charge, I feel like that answers their question. It doesn't expand anything that hasn't been previously instructed. And it may clarify that issue.
Right.
Because it does seem like they are, at the moment, deadlocked as to the first indicted theory of the
Oh,
case.
I have no idea if they're deadlocked or not, but closing arguments, that's when you all explain that. You're allowed to explain that. Of course, the court gives the jurors the law. And if you all go afield in your explanation and closing argument on what the law is, that's when I step in. So the court is, for that question, I note your objection. The court is going to send the answer with reference to your inquiry. You have all the law before you. Please continue your deliberations. And I previously stated what the answer will be for the first question as well.
Yes, Your Honor.
All right, we can go off the record, and Cindy, if you can print that section out for me, and both state and defense, if you all look at that and make sure that's the answer we agreed upon.
Yes, Judge.
Yes, Your Honor.
Oh, and both parties, I'm assuming no objection to just sending the questions and the answers back to the jurors?
No, Judge.
All right. Yes, and Chick-fil-A. Oh, defense?
Yes, Judge.
And Rashawn, on Archaea, there's supposed to be no driving for the remainder of probation. And so we're just waiting for Mr. Hunter, correct? Just give me one moment. All right, we are on the record in 2019 CR 12495 State versus Taymor McIntyre. Could I have parties announced for the record, please?
John Hunter, Thomas Lane, or Mr. McIntyre, you're on.
All right, it's the court's understanding from the deputy that a verdict has been reached in this case. This is what I'm going to tell all the parties who are present in this courtroom. There's not to be any outbursts. If there's an outburst, what's going to end up happening is a deputy is going to tap you on the shoulder. There's no need to get into a conversation with the deputy. That tap on the shoulder is meaning that you are to leave this courtroom and you will only be allowed back in this courtroom if you're going to be a witness. Does everyone understand?
Yes.
Is there anyone who cannot do that? So both parties for the state and the defense, if you need to talk to members who are currently in court that are either with the state or defense, you may do so now. Otherwise, I'm going to bring the jury in.
Everyone knows to be on their best behavior, Your Honor.
All right, let's bring the jurors in.
All right, for the jury.
All right, everyone, please be seated. All right, ladies and gentlemen, it's my understanding that you've reached a verdict in this case. Is that correct? And is that verdict unanimous? All right, if you will give the verdict form to Deputy Laura, please. Thank you. All right, if the defendant could please stand. We, the jury, find the defendant, Taymor McIntyre, not guilty of the offense of capital murder. What did I, excuse me, no. No, out of the courtroom, out of the courtroom now.
Yes.
All right, ladies and gentlemen, you don't ignore that. Sometimes, as you can tell, people are invested, correct? So it says, we, the jury, find the defendant, Taymor McIntyre, not guilty of the offense of capital murder as charged in the indictment. We, the jury, find the defendant Taymor McIntyre guilty of the lesser included offense of murder. Does anyone wish to have the jury polled?
Yes, Your
All right, ladies and gentlemen, and do you want them polled as to both counts?
Honor. As to the count of conviction.
All right, you may be seated. Ladies and gentlemen, I'm going to ask you if, in count two, the guilty verdict for murder, if that is your verdict. If that is your verdict, I'm going to need you to respond yes. Does everyone understand? So we'll start on this end and work our way down. Is this your verdict? Is this your verdict? Is this your verdict?
Yeah.
Is this your verdict?
Yeah.
Is this your verdict? Is this your verdict? Oh, yes. All right. Back row. Is this your verdict? Is this your verdict? Is this your verdict? Is this your verdict?
Yes.
Is this your verdict? Is this your verdict? All right, ladies and gentlemen, what's going to happen now is I'm going to allow you all to have your recess for lunch, and then we'll begin the second phase of the trial. All right, everyone, please rise for the jurors. All right, everyone, please be seated. So what we will do is I think if we all come back at 2 p.m., that should give everybody a chance to have whatever witnesses they need to have present. So we'll come back at 2 p.m. for the second phase of the trial. All right, thank you. And defense, is my understanding that you are going to be requesting a hearing outside the presence of the jury on the witness's expertise?
Well, Your Honor, before we do that, I guess if I could take up a collateral matter that
Sure.
informs this decision.
Okay.
Before the trial started, maybe several months before the trial started, the state filed a motion advising that they would be asking Your Honor to stack the sentence, in this case with the sentence in Fort Worth.
Mhm.
And obviously, that's a matter we will be taking up after the jury's verdict on punishment. But I wanted to make sure that there was no issue with my ability to argue that that motion was in play. In other words, to apprise the jury of the fact that there is petition by the state that whatever sentence is returned in this case be run consecutively.
Well, I don't think that's going to be discussed with the jury because it's not their decision to make.
Yes, Your Honor, but I think that there's some authority that suggests that unlike parole or matters like that, the jury needs to be aware that the court has the discretionary power to stack the sentences. Because
No,
if I could just, there's a couple of cases I think that
Sure.
maybe call to this point. And I'll read them into the record real fast. The first is Vargas versus State, Vargas, 252 Southwest 3rd, 876. That's Court of Appeals, 14th District of Houston, 2008. And Halliburton versus State, Haliburton, Court of Criminal Appeals, 1979. And in these cases, there's discussion about, in one instance,
well, let me stop you for a moment, counsel. So here's the question. Is any witness going to be called who's going to be able to say to this jury that stacking or not stacking is completely up to the court? If there is not going to be a witness, then we can take up whether in closing argument or however you want to let the jury know that the court it's the court's authority to decide whether a case is run consecutively or concurrently. We can take it up at that point.
right, because I mean, fundamentally, it wouldn't be a witness, it would be a charge to the jury.
Okay, so we can take that up at that point.
But I just didn't, I would like to talk about it in an opening. I won't if we haven't ruled on it yet, but
Yeah.
I think that because the law seems to indicate jurors are entitled to know, I thought it would be best if we could talk about it in an opening, and I wanted to give you.
We can take it up in closing. I think that will probably be best.
Yes, Your Honor, I understand.
Okay.
Just a moment.
Sure.
We can go ahead and proceed with the hearing outside the presence on the fingerprints, Your Honor.
Okay. All right, and so it's the court's understanding this is simply going to be a hearing.
Then we should proceed forward.
All right, so my understanding, this is just specifically a hearing to make a determination on whether or not the witness that the state is calling as, I'm assuming, a fingerprint expert,
Yes, Your Honor.
whether or not they're qualified.
Well, my challenge would be to their qualification, and I would challenge the science of fingerprinting generally under the Daubert-Kelly standard.
All right, let's bring them in. State, call your witness. If you'll take a seat here, please. And if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. If you'll put there should be a little clip a square.
Mhm.
If you'll put that on your lapel or somewhere, it's for the court reporter. All right. And Cindy, I am trying to go to your link. And let me see, it may not be working. Just 1 second. All right, have it. Thank you. All right, if you'll state your name and spell your last name for the record, please.
Mia Valdez, last name Valdez.
All right, you may proceed.
Thank you, John. Ms. Valdez, can you please just tell us what's your occupation
I'm a fingerprint examiner for the Bear County Sheriff's Office
and how long have you held that position?
for 2 years.
And how do you, do you have to go certain type of training?
Yes,
What type of training is that?
yes, we go through a 2-week course to learn and identify as well as classify fingerprints, and then as well as on the job training.
And so you stated 13 years?
2 years,
I'm sorry, 2 years?
2 years.
Okay, 2 years. And this training that you are having on the job, is that every day you come in, is there certain criteria they have to meet, or how do you go about your daily duties?
We typically review the fingerprints of every inmate that is brought into the jail.
So numerous.
Correct.
And have you ever testified in Bear County before,
Yes, sir.
associated with fingerprints?
Yes, sir.
And what is a fingerprint?
A fingerprint is an impression made up of characteristics that is used for means of identification for an individual.
And can you describe what an inked print means?
An ink print is typically used with an ink pad as well as an ink print card that is also an impression of a means to identify an individual.
And these unique characteristics, through your training and experience, have you ever come across or known of anybody having the exact same fingerprint?
No, not in my experience.
And so when you say unique characteristics, does that mean fingerprints are unique and identifying for every individual?
That is correct.
And is this something that's accepted across your line of expertise as an examiner?
Correct.
And can you just describe briefly the different characteristics of a fingerprint?
Oh, so typically they have 12 different characteristics consisting of ridge endings, bifurcations, island ridges, and other multiple characteristics to identify the fingerprint.
And again, this field of fingerprint examination is an accepted practice.
Correct.
We'll pass a witness, John.
Can I proceed?
Yes.
Thank you, Your Honor. Good afternoon, ma'am. How are you?
Great. How about yourself?
I'm well, thank you. So in terms of what you have been called here today to do, were you asked to give an opinion about comparison of fingerprints?
Not an opinion, so per se, but yes, to identify fingerprints.
Okay, now, when you say not an opinion, you were asked to look at some inked fingerprints that you did of Mr. McIntyre here in this courtroom about 15 minutes ago, right?
Correct.
And you were also asked to look at what I imagine was a drop card that had been taken on a previous date.
Correct.
And that drop card, did it contain any information on it, or was it just the fingerprints?
No, it is a part of the booking sheet, so it had name, date of birth, and other identifiers.
So it was a booking sheet,
Correct.
was not a judgment.
I was reviewing judgments, but there was also a booking sheet.
Well, did you compare it to booking sheet or to the judgment?
Both.
You compared it to both a booking sheet and a judgment.
Correct.
Okay. And those things obviously had a name on it.
Correct.
Associated with both the judgment and the booking sheet.
Correct.
I guess it was the same name.
Yes.
I gather you're going to testify that name was Taymor McIntyre.
Correct.
And you believe that that's the same individual that you just took prints of?
That is
today,
correct.
correct? Okay. So to be fair, you were not given anyone else's fingerprints to compare it to, right?
No, sir.
And you are aware of why you're here and what you were called up today to do, right?
Correct.
You're aware of this trial generally.
Correct.
And so the prosecutor was asking you this specific question in the context of being able to prove up a prior judgment for sentencing.
Correct.
And you have not given the work that you did in this case over to any other examiner to see if they could check your work.
No, sir.
And that's not a common practice that's done by your department in these kinds of situations with inked prints, correct?
Correct.
Now, you talk about the unique characteristics of an individual that appear on their fingertips that would leave these telltale markings, right?
Correct.
Do you know if what scientific work has been done to confirm whether or not that is a universal truth about the human condition, that every single human being alive has genuinely a completely different fingerprint?
That is not a part of my department to research that.
Okay. Do you know whether or not there's been any scientific research done to determine whether people's fingerprints change over time?
Definitely, sir.
Okay. Do you keep up with any literature in the field discussing potential problematic areas in fingerprinting or places where a fingerprint examiner might make an error?
Yes, sir.
Okay. And are you aware that errors can be made in fingerprint examination?
Yes, sir.
Can you talk to the judge a little bit about the ways that you've been trained to look out for errors and mistakes?
In terms of mistakes, there is multiple reasons. It could be unable to read a fingerprint due to scarring, burning, or anything of that matter. We also encounter amputees to where we don't have a fingerprint to discover. And then as it changes over time, it does become a little bit more difficult to read the fingerprint.
When you say as it changes over time, you mean as a person gets older?
Correct.
Okay. So fingerprints that were taken when someone was 17, 18 years old may be different than they are when they're 25.
No, not necessarily. It has to be like a wide age gap.
Okay. Say not necessarily. I mean, you can't speak specifically to how many years it is before someone's fingerprints might show different characteristics.
Not a specific number, no.
Okay. And admittedly, what you're doing here is you're looking at the exemplar print and you're looking at the print that you're asked to compare that to. And you're eyeballing visual characteristics of how the ink appears on the paper, right?
Yes, sir.
And did you make any drawings or rough notes or sketches
No,
to
sir.
document that?
No, sir. I just fingerprinted.
Okay, so it's just something that's in your head based upon what you saw with your eyes.
Correct.
And so even if we had another fingerprint examiner here today to try and check your work, they wouldn't really know exactly what were the things that you keyed in on.
Correct.
They'd have to make their own independent evaluation.
Yes, sir.
Do you know of any other scientific discipline where the answer to your question has been predetermined in advance by the people asking it of you?
No, sir.
Okay. I'll pass the witness.
Any further questions?
No more questions. Your Honor.
All right, the court will hear argument.
Your Honor, I think that we don't have the Daubert-Kelly standard satisfied here. This is something that was done here in the last 15 minutes. There's been no attempt to check the work, to have it peer reviewed, to have it assessed by anyone else. The witness is not fully familiar with all of the literature about the potential pitfalls of comparison. The witness does not have any documented example of the work that was done by the visual examination conducted here in the courtroom today. So there will be no way to independently criticize that work or vet it, because the next person we bring in would just themselves have to do the exact same visual eyeball observation. So what we're doing here is we're asking someone who has a 2-week course on identification that talks about the basics and 2 years of on-the-job experience, looking at print that they've been told in advance is likely belonging to the same man that was fingerprinted in the courtroom, and giving a confirmatory example. That's not a scientific pursuit, although it is a question that touches upon scientific evidence. And we know, both from popular culture and from just the way that we verbally discuss the concept of a fingerprint, that people do place undue emphasis on what a fingerprint.
So
can
you're
tell you.
saying that the state told her that this is the person and this is their fingerprints?
I think that was the witness's testimony.
No, I'm just saying, is that what you're saying?
I believe that's what the witness testified to.
Okay, all right.
I think that that is definitionally unscientific, and that it should not be admitted under Rule 702 or Daubert and Kelly, that does have inherently a due process component to it. And so we would object to the testimony.
All right, state response. He said that you told the witness who the fingerprints belonged to.
Well, Your Honor, no, we asked her to compare the person that she fingerprinted today with the fingerprint. And she did that, and she identified that it was the same person that she just fingerprinted in court. The underlying validity of this technique hasn't been applied properly, and she has the experience and the training to be an certified, a fingerprint examiner. So the state's position is, one, in a sense, defense is saying that the state has asked somebody to lie on the stand, and I take offense to that.
That is not what we're saying, Jason. And you know
Well, I
that's
mean,
not what we're saying.
in a backdoor way, Judge, that's what he's saying, so I don't
It's not even
appreciate
in a
that.
backdoor way. No, that's not what we're saying.
All right, so here's the thing. We cannot speak over each other. I'll let the state finish, and then defense, I'll allow you to respond.
So Judge, and another premise that we asked an individual to come up on the stand and identify somebody just for the reasoning of having a fingerprint match. The state would, is not in that, would never put themselves in that position due to ethics and also following an oath that has been taken. So in this particular case, Your Honor, the state simply asked Mia Valdez, a fingerprint examiner for Bear County Sheriff's Office, to see if she could identify a fingerprint that she identified the person that she took fingerprints in today, and then compared that to a judgment and identified that person as Taymor McIntyre.
All right, now your response.
Your Honor, the testimony of the witness was that she was presented a booking sheet and a judgment. Now, perhaps the witness has those documents in front of her and would produce them as court exhibits so that we can clear this up. But my understanding of the words booking sheet and judgment are that those documents contain the name of the defendant. The witness also testified that they are aware of this case and who is being prosecuted and what this case is about generally.
So you're not saying that the state told her that this judgment is for your client?
What I'm saying is the state gave her documents that contain identifying information on them and
Right, but
asked them to.
But I just want to be clear because I need to make a ruling. So you're not saying that the state gave her a packet, gave her documentation and says, we're giving you this documentation. It goes with your client. So bring us this information.
I am not accusing Mr. Garahan or anybody else in the district attorney's office of telling the witness what to say
Okay.
or violating in any way their ethical obligations. And I'm so sorry that you perceive it that way. I can't fathom that's how you perceive it, but I'm sorry. My purpose in making the argument is the witness has testified that they reviewed judgments and booking sheets. I've never seen a judgment or a booking sheet ever that don't have the name of the defendant on them.
Mhm.
And the witness also attested to the fact that they know who Mr. McIntyre is, or at least they testified they're aware who's on trial, which
Okay.
would give them the name of them. So, I mean, it doesn't have to be that someone went in there and said, now listen here, I need you to testify that that man there is Taymor McIntyre and he's the same man that's on this drop sheet.
Okay, so I understand your argument. So the defense's motion is denied. The witness will be allowed to testify. With regards to opening statements, you are allowed to let the jury know that the court makes the decision on whether sentences run consecutively or concurrently, the end.
Thank you, Judge.
All right, so if you can step down from the witness stand, I'm going to bring the jury in. And let me ask you all, does anybody have let me see if I have a copy of the indictment. I don't know, is there an enhancement in the indictment or no? So it's strictly from motions.
It's strictly a motion to stack the sentences from the state.
Okay. And I'm assuming that your client is not pleading true to the prior.
Well, Your Honor, it's not, it isn't alleged in the indictment and it isn't being used as an enhancement because it wasn't a final conviction.
No, I understand that.
Right.
But I'm asking, is the witness going to come and testify, or is your client planning on saying that he is in fact the person who has this prior judgment or no?
We are not going to plead true.
Okay, that was my question.
Sorry,
All right.
I'm sorry, but we're not pleading true.
Okay.
witness took the mic. Is she the first witness?
Yes, she's the first witness. Nobody read your sign that said, do not take the mics. All right, to the advocate, can you make sure that the witness still has the mic and not to lose the court reporter's mic?
Okay, good.
Thank you.
That's the one that goes right there. We got it, Judge.
All right, thank you. Yes. Second phase of this trial. Each party will have a chance to give you their opening statements for this phase of the trial if they choose to do so. State, are you prepared to proceed?
Yes, Your Honor.
All right, you may proceed.
We'll waive our opening, Your Honor.
All right, defense.
Thank you, Your Honor. May it please the court,
opposing counsel, ladies and gentlemen. Again, I want to thank you all very much. Obviously, at this point, it's clear that there are some things that we disagree about. That's okay. Also clear that there are some things we do agree. I'm glad to be on that same page with you as we proceed forward. We're here to decide the appropriate punishment. And that's an extremely difficult decision. That might be the most difficult part of any homicide case. The state is going to tell you about Mr. McIntyre's past criminal history and about things that were going on while this case that you all have heard was developing. You're going to hear about Mr. McIntyre's pending case for a murder charge in Fort Worth, where he was found guilty and he was punished for it as an accessory to the crime, as a part of it, not as the man who pulled the trigger, not as someone who was the direct and proximate cause of someone else's death, but as a participant in that criminal activity, much like you were charged in the law of parties in this case. You're going to hear evidence that Mr. McIntyre was on bond for that case when that happened. You're also going to hear evidence Taymor McIntyre was 16 years old when this happened. He was a child. You're going to hear evidence that Taymor's childhood up to that point was far from idyllic. He was in the foster system with his sister. He was brought back to live with his father, who was extremely physically abusive to him, breaking bones, breaking ribs. He had to run away and go live with his sister in Corpus. You're going to hear about how that affects him and how it impacts his judgments. We need to always remember as we go through the evidence in this portion of the trial that we are looking at this whole circumstance through the eyes of a 16-year-old boy who has had a traumatic, horrible life and whose judgment was impaired. You heard testimony in the guilt innocence phase about the fact that Mr. McIntyre had consumed LSD the night before. And while a lot of time had passed before the incident that you all considered in guilt innocence took place, we have to acknowledge that there are impacts on his perception of this situation. Now, we talked in jury selection. Intoxication is not an excuse. Intoxication is not a reason why someone should not be held criminally responsible. But it is absolutely something that you all should be considering when you're deciding what is the appropriate punishment. The punishment range for first-degree murder in Texas is anywhere from 5 to 99 years or life in prison. And that's a huge range of time. And we understand, I think, that not all murders are created equal. While we go through this, I ask that you all have some patience with me and bear with me. Because while I know that we all agree on one central thing, which is that there was not enough evidence to convict Mr. McIntyre of capital murder, there was not enough evidence that Mr. McIntyre robbed anyone, we certainly have differences of opinion about different aspects of this case, which I'm going to do my very best to respect. But I don't know exactly why each of you made the decision that you made in the guilt innocence phase. Some of you may have made it for different reasons. You only need to be unanimous about the ultimate conclusion. So there are things that I'm going to talk about that you may think, well, that's him talking about self-defense. And I've already heard that, and I don't believe it's self-defense. And come on, like, stop talking about self-defense. But remember, just because someone isn't 100% in the right doesn't mean the other person isn't partially in the wrong. And we have to acknowledge that every human interaction is a two-sided coin, and that there are aspects about Mr. McIntyre's perception on the world, his understanding of what was going on, the events that led up to being in that car with Mark, that have bearing on how responsible he should truly be in the grand scheme of things. Those are things that I ask you all to still consider, even though I gather you all have rejected the idea that what was done was justifiable by self-defense or otherwise. Keep those things in mind. Also keep in consideration things that relate to how Joanna behaved in all of this. Well, I understand that you all found Joanna credible enough to accept her testimony for the purposes of overcoming the accomplice witness rule, and I can understand y'all's reasoning there. Please also understand there are significant reasons why we should be suspect of Ms. Reyes's testimony, and those reasons have additional bearing into how you should make the decision to punish. Remember, Mr. McIntyre was 16 years old when this happened, but Ms. Reyes was 19 years old. Jeremiah was 19 years old. Mark was older than him. Jalen was the closest in age, but still older than him. Taymor is the youngest person in that car. And Taymor is now here in front of you, asking you all to decide how to punish him for this horrible, tragic thing. And keeping that aspect in mind, the motives of the other people, why things were done the way they were, all should be brought to bear, right? The fact that his presumption of innocence has ended does not mean that you all cannot continue to give some credence to the fact that Mr. McIntyre is, like all of you, a human being. And he deserves to have dignity in the way that his punishment is considered. And I want you all to think about some things that are surrounding the circumstances of this case. Because what we're here to talk about is not going to bring Mark back. It is not going to right any of the wrongs that you all have passed judgment about guilt and innocence on. Those things are not fixable. No matter what we were to do, we can't take back time. We can't take back these decisions. We are all having to move forward. And I would submit to you that the criminal justice system and the way that we handle carceral punishment of people, locking people away, is just one idea out of many in how we address these otherwise unsolvable problems. It is good for the human heart. It's cathartic to try and see that someone is being punished for what they've done. And I understand that. There's nothing wrong with that desire that we all feel, all experience when we have identified that someone has done something that offends the values of society and that puts us in danger. And I respect that. But we have to also understand that it doesn't do any good to solve one wrong by committing another. And I would submit to you that because you will be asked to consider a wide range of punishment, and I would expect that what will be sought from the state of Texas on your behalf as the punishment will be an exceedingly long term of years, to remember that there might be other ways to address problems in society than warehousing human beings. James Joyce, the Irish author, once famously said that Ireland was like a sow that ate her own piglets. And I worry sometimes that in America, that's what we have. We have children who are trapped in the foster system, children who are the victims of abusive parents, of parents with substance abuse problems, children who don't have any chance of having a proper moral compass, a proper guiding system. They have to figure those things out for their own. And unfortunately, they have to do that by trying to live in an adult world as a child. That's a pretty impossible ask. And yet we do it. And we arrest them. We certify them as adults. And we take them to trial. We send them to prison for the rest of their life. The world just keeps on turning. Folks, I just don't see that as being a sustainable model. It doesn't make anything better. It doesn't make anyone better. A little kindness, a little compassion, even in the face of something that we can all agree is evil, wrong, not acceptable, is always the better road to take. At the end of this, you'll all be asked to make that decision. We can't walk it for you. It's going to be personal to each and every one. All we ask is that you hear the evidence, that you understand we're not trying to paint this boy as a saint. And I'm not asking you to forgive him for what he did. I'm just asking you to keep it all in perspective. I understand that while it's easy to say, did something evil, we're going to throw you away. As the prosecutor said in her closing argument, if Taymor treated this boy as a piece of trash, then the implication should be that you should treat him as a piece of trash. Isn't always the answer. Yes, the Bible talks about eye for an eye, but that's the Old Testament. And there is good news, and it's to turn the other cheek. I'd ask you all to keep these things in your mind as you hear the evidence. I thank you all for your deliberation and your patience with us at this point.
All right, state, call your first witness.
Yes, Your Honor, the state calls Mia Valdez.
if you can raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand if you'll state your name for the record and spell your last name, please.
Mia Valdez, last name Valdez.
All right, state, you may proceed.
Thank you, Your Honor. Ms. Valdez, can you please tell the jury what's your occupation?
I'm a fingerprint examiner for the Bexar County Sheriff's Office
And how long have you been an examiner there?
for 2 years.
And did you go through a certain training to become an examiner?
Yes, sir. I went through a 2-week course for identifying and classifying fingerprints as well as on-the-job training.
And have you testified here in Bexar County before?
Yes, sir.
And why don't you describe to the jury just what a fingerprint is?
Fingerprint is an impression consisting of characteristics that help identify an individual.
And what about an inked print?
Inkprint is the same thing, is used with the ink pad and an inkprint card used for impressions of characteristics to identify an individual.
And so on these ink prints, are you able to compare ink prints with other ink prints? And can you please just describe to the jury how that is done?
Usually we use 12 set of characteristics to identify an individual using multiple methods. And then we're able to point out ridges and stuff like that for the identification.
And are you able to compare, well, one, are there unique characteristics to every fingerprint?
Yes, sir.
And are any two fingerprints, have you come across or known about any two fingerprints being the same?
No, not in my experience.
And I'm going to show you what's marked state exhibit number P1. Please tell me, tell the jury, one, can you identify that?
Yes, this is an inkprint card.
And can you describe to them what a print card?
Inkprint card.
Ink print card. Can you describe to the jury what that is?
It is a card that has the impressions of the fingerprint using an ink pad.
And do you recognize this particular ink print card?
Yes, sir.
And how do you recognize it to be?
I was the one who was taking these fingerprints.
And the individual that you took those ink prints from, is that individual in the courtroom?
Yes, sir.
Can you please just point him out and identify an article of clothing he's wearing?
It's the gentleman in the gray sweater.
Now, did you have an opportunity to compare an ink print to another print on a judgment?
Yes, sir.
I'm going to show you what's been marked. State exhibit number P2. Can you tell me if you recognize that document?
Yes, sir.
And tell me how you recognize that document?
This was the judgment that I reviewed.
And is there a print in that packet?
Yes, sir.
And were you able to compare that print with the known ink prints that you took in the courtroom today from Mr. McIntyre?
Yes, sir.
And did you come to determination if those ink prints match on those documents?
Yes, sir. They were a match.
And do you remember which fingerprint that was?
This one was going to be the right thumbprint.
And on that, well, one, the state would offer state exhibit number P2 into evidence, Your Honor. At this time, we'll tender to the defense for any objections.
No new objection.
All right, then states exhibits P1 and P2 are admitted.
Now, particularly on state exhibit number P2, the named individual as the defendant on this, who is that?
That would be McIntyre Taymor.
And then also under the actual charge, what was the charge of the offense?
This was going to be for murder.
And what was the offense date?
Of offense date of 7/26/2016.
So July 26, 2016.
Correct.
And then also on here, what is the plea to the offense?
Not guilty.
And what is the verdict of the jury?
Guilty.
And was there a time assessed?
Yes, sir.
And what was that?
55 years, sorry.
55 years?
Correct.
Onward to, that was under, is that a count one?
Correct.
And under count two, is that also an offense named in that?
Correct.
And what is that offense?
Aggravated robbery with a deadly weapon.
And deadly weapon to it, what?
To with a firearm.
And what was the plea by the defendant?
Not guilty.
And what was the verdict of the jury?
This one was guilty.
And what was the punishment assessed?
This one is for 30 years.
Count three. What was the offense the defendant was convicted of?
Aggravated robbery with a deadly weapon to wit a firearm.
And in this particular case, what was the plea?
Guilty.
And then what was the years assessed?
13 years.
For count four. What was the offense which the defendant was convicted?
Aggravated robbery with a deadly weapon to wit a firearm.
And what was the plea to that offense?
Guilty.
And what was the punishment assessed?
13 years.
I'll show you when it starts. P4. Can you look over that and tell me if you recognize that?
Yes, sir.
And looking at this document, is there any identifying numbers on there?
Yes, sir.
And also a name
Correct.
and also a date of birth?
Correct.
And does the SID identifier match the SID identifier on the judgment?
That is correct.
And do you know that this to be a booking photo?
Correct.
Judge, at this time, the state would, oh, I'm sorry. What is the identifying number of SID?
It's gonna be the state ID number.
Can you call that out, please?
It's gonna be TX 164-60189.
And on state exhibit number P4, does that match that SID number on that document?
That's correct.
At this time, Your Honor, the state would move into evidence P4, will tentatively transfer any objections.
No new objections.
All right, State's Exhibit P4 is admitted.
Thank you, Judge. May I just publish to the jury?
Yes.
And this is what was identified as P4, and those are booking photos of this individual when he was booked in Tarrant County.
Correct.
Thank you. And again, he was convicted of 1 murder and 3 aggravated robberies.
Correct.
Thank you. We'll pass the witness.
All right. Defense, you may proceed.
Thank you, Your Honor. One and two right there.
Do you have your microphone? Mr.
So
President?
sorry, I walked off. Work okay. To show you what has been admitted as states two. This was the document that Mr. Graham was just going over with you, right?
Correct.
And you indicated that it's Taymor Trayvon McIntyre,
Correct.
and it's out of Tarrant County, correct?
Correct.
And here, I want to call your attention to this portion here. What does the judgment say? Right there.
The sentence shall run concurrently.
Thank you. Pass the witness.
No further questions for this witness.
All right, is this witness excused or subject for recall?
Excused by the state, Your Honor.
Excused by the defense.
All right. The rule has been invoked. You're not allowed to discuss your testimony with anyone during the pendency of the trial. All right, if you'll leave the microphone behind. State, call your next witness.
State calls Anthony Rodriguez.
Right, if you can raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth so help you God?
Yes, ma'am, I do.
All right, you can lower your hand. Make sure you put the microphone on, please. And if you could state your name and spell your last name for the jury.
My name is Anthony Rodriguez. I spelled ANTHONY RODRIGUEZ.
All right, state, you may proceed.
Sergeant Rodriguez, how are you currently employed?
I'm an investigator with the Bear County District Attorney's Office. I hold the rank of sergeant. I'm a criminal investigator.
And how long have you been with the Bear County District Attorney's Office?
I'm just over 12 years. February was my anniversary date.
Okay. Before becoming employed with the Bear County District Attorney's Office, where did you work?
I spent 12 years with the Bear County Sheriff's Office prior to coming here to the DA's office.
Okay, and when you worked with the Bear County Sheriff's Office, what was your title or assignment?
For 10 years, I was the gang intelligence officer for Bear County.
Okay, and did you specifically undergo any training regarding recognition of criminal street gangs?
Your Honor, can we approach?
Yes. All right, everyone, please be seated. And my understanding is the witness is going to testify to potential gang affiliation or something of that nature.
That's correct, Your Honor.
All right, so I'm gonna let the state ask their questions so I can see where this is going, and then I can hear objections and see whether there's a need for a hearing on expertise.
Thank you, Judge.
All right, you may proceed.
Sergeant Rodriguez, so you said that during the Bear County Sheriff's Office, you spent 10 years doing what?
I was the gang intelligence officer of the Bear County Sheriff's Office.
Okay, and regarding any training and experience that you had, can you just briefly go over that to the court?
Yes, I'm a member of the Texas Gang Investigators Association, also the International Latino Gang Investigators Association. I have received training through the Texas
Excuse me.
Commission.
Y'all have dim the lights. Thank you. All right, I'm gonna continue.
You have additional training through where?
Through the Texas Commission on Law Enforcement Standards and Education, otherwise known as TCO. But the primary form of my training was on-the-job training, interviewing gang members over those 10-year period, learning about the gangs from the gang members themselves.
Okay, and so I guess while you were employed with the Bear County Sheriff's Office, did you spend some time in classification?
Yes, ma'am. So my primary job location was at the classification section. My primary duties were to house inmates, gang members specifically.
Okay, and so as a part of being a classification deputy, did you routinely conduct interviews with documented gang members?
And undocumented, yes, ma'am.
Okay, and do you have any other additional training regarding the recognition of criminal street gangs?
Outside of what I just mentioned, no, ma'am.
Okay, and as part of your current employment, do you keep updated with any literature or training materials regarding gang identification?
Yes, ma'am. So I'm still an active member with the Texas Gang Investigators Association. I am also a liaison to the Texas Anti-Gang Center. I administer all the gang documentation here in the Bexar County DA's office. And I routinely consult for the office as a gang expert.
Okay. Now regarding how you're able to identify defendants as members of criminal street gangs, can you kind of just go over the different ways you would be able to identify someone as a member of a criminal street gang?
Yes, ma'am. So Texas has a central gang database that's legislative. It's required by the law. We refer to that database as Tex Gang. That database requires all law enforcement agencies that are in a jurisdiction over a certain population to report all gang data to that central database. Tex Gang is what I check to see if this individual has ever been identified as a gang member. Outside of that, check to see if he ever been incarcerated in any other jurisdictions or agencies. Therefore, I can check to make sure if they've ever documented him. It may or may not have been in Tex Gang. Tex Gang has a lot of rules. One of the rules is that after so many years, it'll drop off the system. So if an individual has been documented, 5 years have passed, it could get dropped off.
Okay. But just regarding incarceration specifically, are you able to reach out to other, county jails or incarceration facilities and obtain documents that are kept in the regular course of business for them when they are classifying and housing defendants in their jail?
Yes, ma'am, I can.
Okay, and did you do that in this case?
Yes, I did.
Okay, and did you review the materials that were sent back regarding this defendant?
Yes, ma'am, I did.
Okay, and then did you form an opinion as to, well, if I could just, Judge, do you want me to just go over everything or just the qualifications for?
The qualifications and then how that is attached to the defendant, if something is attached to the defendant.
Okay,
Any underlying facts and data we'd like disclosed. The witness relied on in rendering his opinion.
well, they've been filed under business records affidavit. I can get you a copy if you'd like.
And I think we have a right to have the witness proffered to the court for the review.
All right,
under
so this is
705.
what the court is going to say. I just want to know from this witness, his level of expertise, how is it related to this specific case in this defendant?
Yes.
And you can pass for.
All right. Now, regarding the defendant, Taymor McIntyre, did you gain knowledge that he was incarcerated in the Tarrant County Jail previously to being incarcerated in the Bexar County Jail?
Yes, I did.
Okay, and did you reach out to Tarrant County and obtain records regarding his classification in the Tarrant County Jail? Did you obtain those records that were regularly kept in the course of business up there?
Objection, this isn't the witness who could attest to what's regularly kept in the course of business in Tarrant County.
All right, that objection is on the roll.
Did you obtain the documents from Tarrant County?
Yes, ma'am, I did.
And did they come with a business records affidavit
Yes, ma'am, they did.
and you reviewed that?
Yes, ma'am, I did.
Okay, thank you. And after reviewing those records, were you able to form an opinion as to whether the defendant was ever affiliated with a criminal street gang?
Yes, ma'am, I did.
Okay, and what gang was that?
He's a member of a Crip gang, otherwise known as the Long Beach Insane Crips.
Okay, and was that determined through a self-identification or what means?
It was determined from a self-identification gang acknowledgement form obtained by Tarrant County.
Okay, and can you just explain to the court what that form is?
So this is a correctional form. It's used in jails and detention. It's used primarily to house individuals. So when somebody comes into a facility, they are approached by what we call a classification officer. This is an individual that houses people in the jail. They're asked a series of questions. One of those questions is going to be, are you a gang member? Many individuals will admit gang affiliation at this time, so they are housed appropriately. They don't want to be housed with rival gangs or things of that nature.
Okay. And do you have knowledge about the Crips Criminal Street Gang?
Yes, ma'am.
Okay. And based on your knowledge of that gang, do you have an opinion as to the purpose of that gang?
It is a criminal organization. It's a group of individuals that are together for the purpose of committing criminal activities.
Okay, and in your training and experience, what type of criminal activities would those be?
They range everything from narcotics all the way up to murder.
So we pass the witness, Your Honor.
Thank you, Judge. Good afternoon, sir. How are you?
Excellent, sir. Yourself?
I'm doing all right. You indicated that you checked databases to see whether or not Mr. McIntyre was listed as being affiliated with the gang, right?
Yes, sir, I did.
And you mentioned Tex Gang is a statutorily required, statewide database about gang affiliation in prisons.
Yeah, no, not in prisons, jail. Oh, well, by law enforcement, not exclusive to just jail.
Okay, just so it could be people on the streets, people in jails, people in prisons.
Not prisons, everything but prisons. I checked a separate database for that.
Okay. Are you aware that many gangs have different organizational structures for people who are incarcerated versus people who are out on the street?
I'm gonna
Yep.
object as to, well,
How is that
outside of the scope of
relevant?
this hearing.
It goes directly to disqualification.
All right, so. I will hear objections and rulings. All right, you can answer the question.
Can you repeat the question, sir?
You're aware that oftentimes when we talk about a criminal gang, that gang may have people on the outside and it may have people on the inside. They often have different organizational structures, right?
That's possible, yes, sir.
Okay. And was it, just so we're clear, was it Tex Gang that you consulted that actually said Taymor McIntyre is a member of this particular gang?
Yes,
Okay, so it wasn't an independent document from Tarrant County, or it was a document from Tarrant County in Tex Gang? Can you just explain
sure,
your method of determining this a little bit more clearly?
sure. Tex Gang has a 5-year requirement, meaning that if you're in the system for 5 years and you're not validated, meaning that another law enforcement agency hasn't added to Tex Gang, you are dropped off the system. So McIntyre was in Tex Gang from a earlier admission. He had since dropped off Tex Gang. However, Tex Gang still showed that at one point an entry was made. So to answer your question, I had to do both. The first thing was I acknowledged that there was an initial entry in Tex Gang, but to validate that initial entry to ensure that it is in fact the defendant, I reached out to the county that entered that information, and that county is Tarrant County.
Okay, so to be clear, if we were to go look him up right now, Mr. McIntyre is not in Tex Gang.
He had since dropped off Tex Gang, yes, sir.
5 years ago.
After 5 years. So the original entry date, I believe, was 2017.
Okay, I see. Gotcha. So what? Three years ago,
Yes, sir.
something like that.
Yes, sir.
Okay. You mentioned that Long Beach Insane Crips is a criminal enterprise, basically. Is that your testimony?
The Crips gang is a criminal organization, yes, sir.
Okay, when you say the Crips gang, you understand that there are lots of different subsets of what you'd call Crips, right?
Yes, sir, there is.
And that many of them have no affiliation with each other whatsoever, right?
That's true, yes, sir.
In fact, some criminal elements that would call themselves Crips are actually fighting each other, right?
That's true.
So we can't say that it's just Crips, therefore it's a criminal enterprise, correct?
Are you talking about this particular gang or all gangs?
I'll withdraw that question. Let me ask you more specifically. Have you ever investigated, other than Mr. McIntyre, any other individual person who's a member of the Long Beach Insane Crips?
No, sir, I have not.
Have you ever encountered anyone who is a former gang member from the Long Beach Insane Crips?
No, sir, I have not.
Do you know anything about the organizational structure of that entity, the Long Beach Insane Crips?
I have some knowledge of it, yes, sir.
Okay, well, when you say you have some knowledge of it, is it based upon your own investigative work?
Yes, sir.
Okay, but you indicated you never investigated anybody associated with that gang, so help me understand.
I never investigated a person associated with that gang, but I have looked into the gang.
Okay, when you say you've looked into the gang, were you talking about Google or talking about something more?
So, sure. So we get reading material that's nationwide, primarily from the International Latino Gang Investigator Association, also from the Regional Organized Crime Investigation Center, that provides reading material from various law enforcement agencies throughout the country. This particular gang, the one you're asking about, sir, is a California-based Southern gang. So when I learned of this particular group, I went to that reading material from the southern part of California. There, I was able to learn a little bit more about this gang.
Okay, well, I mean, so for example, my guess is you have more dealings with some of the Latino gangs here in San Antonio, right? There are quite a few of them in the jails here.
Yes, sir, there are.
Okay, so for example, you know that what is going on in Los Angeles with a gang like the Latin Kings isn't necessarily reflective of what anyone who calls themselves that in San Antonio is doing. You understand that happens a lot, right?
I mean, it's kind of a broad question there, sir. There could be some takeaways from incidents in one state that carries over to incidents in this state.
But oftentimes there's no similarity, right? There are plenty of gangs who don't do the same things or have the same structure in one state versus another. You'd agree?
I cannot agree with that, sir, no.
Okay, you think that all people who affiliate with a gang in every single state where they might be locked up all are working under a common objective?
That's why it's called an organized criminal gang, sir. They have an organized structure, they have rank, they have written constitution and manifestos that allows them to remain a structured, organized group,
Okay.
regardless of the state or the location.
Do you have the manifesto of the Long Beach Insane Crips?
I do not, sir.
Do you have any idea who's the leader of the Long Beach Insane Crips?
No, sir, I do not.
Do you know who's the sergeant at arms for that organization?
No, sir, I do not.
Do you know if they even have a sergeant at arms?
I'm sure they do, sir.
I'm sure they do, but do you know if that's what he's called?
No, sir.
Okay, so you don't know anything about the structure of the gang, right?
I have some knowledge about it, sir.
Okay, you read a publication from someone in Southern California.
Yes, sir.
Who authored that publication?
I don't know, sir.
Okay. You understand that when people get classified, there are often reasons other than organized criminal activity why they might want to be associated with a particular group of people, right?
No, sir, I do not.
Okay, well, do you think that someone who's African American going into a jail would say, I'd like to join the Aryan Brotherhood, mark me down as an AB?
Objection, relevance.
Sustained.
Well, I mean, you understand that there are racial reasons why people join particular groups in jails, right?
Objection, relevance, and outside the scope.
Your Honor, he testified that,
This is outside the scope of the expertise. I think that my understanding from both parties that the purpose for questioning this witness is to determine whether or not he's an expert in whatever field he's being presented, which appears to report that he's being presented as an expertise on gang affiliation or gang classification. And then the other question the court wanted to know was, how would that be relevant to this case, whether or not it's tied to your client or not? So if we could remain within the bounds of this actual hearing.
Your Honor, I think that pretty well establishes what my objections be. I'm ready for argument.
All right, court will hear argument.
Your Honor, the witness is not sufficiently familiar with this organization to be able to give an opinion about whether or not it truly is a criminal enterprise and whether or not Mr. McIntyre is even still a member of it. He has a notation from a database that is no longer considered active by the database, that when he was first booked into Tarrant County or at some point in the past while in Tarrant County, he was affiliated with this organization. We're backdooring hearsay. I have no ability to confront the individuals who screened him or as to how he was screened or whether he even got to participate in the screening process or whether it was done for him. The witness has no personal experience with anyone affiliated with the organization. He's basing this off of what's basically a trade publication from someone in law enforcement in Southern California without any understanding about how that relates to San Antonio or Texas generally. And I think that under those circumstances, he's not qualified to testify about this organization for any purpose. It would backdoor in hearsay that violates the confrontation clause. And its prejudicial effect is through the roof. And there's not even any indication that Mr. McIntyre is still involved with these people.
So this is what the court's question is. One, gang affiliation is allowed as relevant information during punishment. The court is finding that this is relevant, but the next question the court wants some clarification on is when is this alleged affiliation to have occurred?
So I have the exhibit that I would offer through this witness, but it was when the defendant was incarcerated in Tarrant County back in 2017. And I mean, he hasn't been out on the street since, so. I think it's relevant. It goes to evaluating the defendant's background and character, which defense has put at issue in his opening statement when he was proffering that the jury was going to hear that the defendant had such a rough upbringing. And this witness is an expert. He has a lot of knowledge dealing with gang members and specifically the Crips. I think Mr. Hunter essentially stipulated that this is a subset of the Crips criminal street gang, and this witness is familiar with that criminal street gang's violent and illegal activities, which he's testified to, and he is able to form an opinion based on the materials that he's reviewed as to the defendant's membership in the organization.
I'm not stipulating to anything. This all is conduct that occurred after the offense date in this case, while he was incarcerated. And the witness is, I don't believe, qualified to tell the jury anything about this organization, much less whether it's affiliated with any criminal entity that calls itself Crips, or what its purpose is, or who its membership are, or whether Mr. McIntyre is a member. And so while I would agree with Your Honor that if we had evidence that Mr. McIntyre did this as a gangland shooting, it was for the purpose of advancing a criminal enterprise, it would absolutely be relevant. There is no relevance to the fact that he was booked into Tarrant County and someone says that back then he identified as being part of this organization. I think that is not relevant. And all it does is to make people believe impermissibly that because of decisions that he made in jail, which you can't really even say are criminal or underhanded, that somehow should have bearing upon how he's punished for this offense that occurred before he was even documented to be a part of it.
So it's not required by law for it to be relevant as character evidence that the offense that we're here for is tied to his gang admission. And it's not somebody just saying this, the defendant said it back when he was in Tarrant County. And so it's a statement against interest, a statement against party opponent. And I mean, this evidence has been filed with the court since December of 2024. So his objections to hearsay and stuff, I mean, there's an affidavit that is going to authenticate this information.
It more to the point is a Crawford, it is a confrontation issue because it's a double hearsay problem. They're offering the statement as an admission by party opponent. All right, fine. But what's being discussed here is not the actual admission by the party opponent. Being discussed here is the entry by a data clerk that he should be classified as a member of a gang that is in the text gang database because of something he said at booking. We don't have the statement exactly that was said at booking. We have a summary of that. So I think that that's the reason why there's a confrontation problem, irrespective of whether it would come in as an exception to hearsay or a non-hearsay statement. But more to the point, I mean, she said a moment ago that it's somehow connected to the offense. There's been no evidence in guilt innocence that it's connected to the offense. I don't.
Or does it have to be connected to the offense?
Well, I think she
And I
argued it
didn't say,
was.
I did not say that. I said it is not required by law to be relevant in punishment to come in. That's not required, that I prove that he was acting under the color of his gang when he committed this
I know you
offense.
said that too, but did you not also argue that
All right.
it's connected to the offense?
I did not say that.
It's going to rule. The court is going to allow the witness to testify. Is there anything else?
No, Judge.
All right, does anyone need a break or I allow the jury to come back in?
I would like a bathroom break.
All right. So if I could have you all back here. 3:50,
Thank you, Judge.
350.
yes.
Thank you, Judge.
Okay, we are still outside the presence of the jury. We're back on the record. Defense, you had another question?
Yes, Your Honor, thank you. Officer, one last thing. You mentioned that this information came to you by way of the text gang database, right?
Yes, sir.
Do you know who exactly is responsible under that statutory scheme for maintaining the database?
The database or the information that entered into the database?
Both.
So TextGang is run by DPS, the Department of Public Safety. And the entering agency is the one that's responsible for putting the information into TextGang.
And does it have any procedures for reports made in error?
Yes, the entering agency is responsible for removing any information that is done in error.
So it would be on the Tarrant County Jail if something in the Tarrant County Jail was made in error.
Correct.
Okay. Do you know if there's any reporting by DPS about the rate of error in the database?
I'm not familiar with that.
Or any reporting on how reliable the database is?
TextGang does an audit every 2 years for that particular reason to try to verify and validate the information going into the database. They're very thorough. I know that because I'm the agency administrator here. So that is their effort for checks and balances.
When you say that you're the agency administrator here, you're responsible for the entries that are made for the Bear County Jail?
District Attorney's Office, not the jail.
Okay, so as to individuals that you prosecute, so prosecutors can independently upload information to the database?
We could, but we don't. We have never uploaded any information in TextGang since I've been the administrator.
Okay, so you have never had to report on your error rate because you don't report that data?
I'm gonna object as to outside of the scope and relevant.
All right, let it be sustained.
If I just may explain why it's relevant and why it is within the scope. The issue here is that we have two things that are being offered. The one is the actual statement or the recording of the statement about Mr. McIntyre professing to be a member of this organization. That's one thing. The other is this individual testifying as an expert on gangs, be able to say that this is a gang that is in the database and that the members of the database are being watched and so forth and so on. And if the witness can't attest to the rate of error of the database, then there are problems with letting the jury understand that this information was uploaded to the database because it gives a sense that it's more reliable than it really is. That's the objection.
All right, the objection is overruled. The witness will be allowed to testify. If you could line the jurors up, please.
All right, for the jury.
Would everyone please be seated? All right, State, you may proceed.
Thank you, Judge. All right, Sergeant Rodriguez, I think we left off on your training and experience. So you're employed with the Bear County District Attorney's Office, is that correct?
Yes, ma'am, I am.
And how long have you been doing that?
I've been with the Bear County District Attorney's Office for a little over 12 years now.
And what are your duties with the Bear County District Attorney's Office?
I'm a criminal investigator. My primary duty is to assist the prosecution with trial preparation.
Okay, and do you have any ancillary duties in your employment?
Yes, so I'm also the gang investigator here. I have a liaison with the Texas Anti-Gang Unit. My secondary job is to ensure that all of our investigators have access to research gang membership and to consult with all the prosecutors here to identify if either the defendant or a witness or a suspect is gang affiliated. I provide expert opinions on their gang membership and occasionally, like today, testimony.
All right, and before you became employed with the District Attorney's Office, where did you work?
I spent 12 years with the Bear County Sheriff's Office before I came to the District Attorney's Office.
Okay, and during your time with the Sheriff's Office, what were your duties?
Started my career as a jailer. I was a jailer for 2 years, and then I spent the next 10 years as the gang intelligence officer for the Bear County Sheriff's Office. My job is with the classification section. It's a section that is responsible for housing inmates. Primary inmates I was responsible for housing were gang members.
All right. And as your duties as a classification officer, what did that routinely entail?
It routinely entailed interviewing individuals that were either suspected or self-admitted members of a gang. And so my job was to talk to them and to ensure that they were in fact an actual member so I can appropriately house them.
Okay. And so it was routine in classification that these interviews would be conducted to appropriately house the defendant, is that correct?
Yes, ma'am.
Okay. Now, do you have any other specialized training regarding the recognition of criminal street gangs?
So I'm a member of the Texas Gang Investigators Association. I've been a member since my time at the Sheriff's Office. I'm also a member of the International Latino Gang Investigators Association. I've received training through both of these associations on the subject of gangs. I've also received training through the Texas Commission on Law Enforcement Training and Standards. This is what we call TCOLE. I've also received some standalone training during the course of my career, but my primary training came from the gang members themselves. Every time I would interview these individuals, they would teach me really, how to recognize their affiliation with the gang,
Objection, relevance, hearsay.
All right, that will be sustained.
Motion to instruct the jury to disregard.
All right, ladies and gentlemen, you'll disregard the last statement
Motion to mistrial.
tonight.
All right. Now, have you or were you, I guess, in your analysis of whether a defendant is associated or a member of a criminal street gang, can you kind of explain to the jury how you would obtain that information?
The primary thing that we do is we simply ask the individual, are you a member? Being that it's a correctional setting, many individuals will self-admit gang affiliation, so they are housed with their own people. We don't put them with a rival gang. Outside of the self-admission, outside of us just asking, there's a number of things that we look at to identify gang affiliation. Gang members are experts in nonverbal communication. We've all seen it, whether it be a tattoo, clothing, gang hand signs. So We have training and expertise in identifying those nonverbal cues to identify gang affiliation. Secondly is the intelligence, whether it be from jail calls or jail mail or other individuals. Finally, we look at the cases. What are they charged with? Who are they charged with? Where do these crimes occur? Are these crimes occurring in neighborhoods that are notorious for a particular gang or gang set?
Your Honor, may I approach the witness?
Yes.
I'm going to show you what's been marked as State's Exhibit P3. Can you take a look at that and pull the reference on?
Yes, ma'am, I do.
Okay, and have you seen State's Exhibit P3 before?
Yes, ma'am, I have.
Okay, and can you explain to the jury what P3 is?
P3 is a gang acknowledgement form. So in a correctional setting, when you identify somebody as a gang member, we want to make sure we capture that information. We capture it by documenting it in a gang form. What I have here in P3 is a gang form.
Okay, and just regarding State's Exhibit P3, I know earlier you spoke when a defendant is classified in the jail, there's documentation. And so did you reach out to the Texas County Jail and personally obtain State's Exhibit P3?
Yes, ma'am, I did.
I'm tendering to defense for inspection, but at this time, the state offers State's Exhibit P3 under Rule 803.
Your Honor, can I void hire the witness about something?
Yes.
Officer, in reviewing P3, there are photographs of Mr. McIntyre without a shirt on, correct?
Yes, sir, there are.
And they document some tattoos that Mr. McIntyre has.
Yes, sir, they do.
You're not testifying that any of those tattoos are affiliated with any criminal organization or a marker of those organizations, are you?
I am not, sir.
Okay. Then no new objection.
All right, State's Exhibit P3 is admitted,
Permission to publish, Your Honor.
granted.
Yes, Sergeant Rodriguez, and so have you had a chance to review the contents of State's Exhibit P3?
Yes, ma'am, I have.
As to the defendant Taymor McIntyre's involvement in a criminal street gang,
Yes, ma'am, I have.
and what is that
Objection,
opinion?
opinion on ultimate issue.
Overrule.
You can answer.
He is a member of the Long Beach Insane Crips.
All right. Now I'm publishing State's Exhibit P3. Can you explain to the jury what this first page is?
When you receive a documents and you want to have them admissible in court, we
Objection,
reject.
Your Honor, relevance calls for a legal
All right, that will be sustained.
motion to instruct the jury to disregard.
All right, ladies and gentlemen, you're to disregard the last question.
All right, Sergeant Rodriguez, regarding this first page, is this something that you received when you requested the evidence from Tarrant County?
Yes, ma'am, it is.
All right. Now regarding this page, I guess, can you see it up there?
Yes, ma'am, I can.
All right. Can you explain to the jury what this page is?
This is the document used by law enforcement to capture and collect information acknowledging gang affiliation.
All right. And just regarding the name of the person, can you tell the jury what that name is?
Yes, ma'am. It's,
Sorry, Your Honor, just for, make sure the record's clear, if I could have a running objection as to the explanations about the content of the document as to my hearsay confrontation and 702 objections. I just want to make sure I'm not objecting all through her
All right.
examination.
All right, you may continue.
Thank you. All right, can you please tell the jury what that name associated with this gang update sheet is?
yes, the name is Taymor McIntyre.
And what is the CID?
That is the correctional identifying number. That is the number used by this corrections agency. It's a unique number specifically attached to Taymor McIntyre.
Right, and regarding the date of birth associated with the defendant,
June 16th, 2000.
and sorry, just to back up, what is the CID associated with this defendant?
That is the specific and unique number given to the defendant by the agency.
And what is that in this case?
What is the agency or the number?
The number.
The number is 0905728.
All right, and can you explain to the jury what the affiliation, moniker, and ranking is?
The affiliation is the name of the gang. So in this case, Taymor has identified himself as a Long Beach Insane Crip gang member. The moniker is the nickname that he uses as a member of that gang. In this case, it's Tay K 47, and he's identified himself as a member of that gang.
All right. Regarding the affiliation or ranking determined by, can you explain that to the jury?
Yes, ma'am. So this, what they're identifying here on the form is how they identified him. In this case, number 3 is selected, indicating that Taymor has identified himself as a member. Number 6 has been selected. There are a number of options under number 6, ranging from gang dress, hand signs, tattoos, or symbols. In this particular case, he provided intelligence on hand signs that are unique to this particular gang. And finally, number 8, which is use of technology or the internet for recruitment.
I'm going to object First Amendment, right of free association, right of free expression.
All right, that'll be overruled.
Thank you. Now, regarding this area, I guess, can you explain to the jury what you reviewed regarding this specific comment section?
These are the notes that are documented by the agency. In this particular case, it is indicating that he self-admitted membership on July 26, 2017 with the Eastside Long Beach Insane Crips. It also indicates that photos were taken of the defendant and social media photos were collected during the course of their investigation.
Now regarding what's depicted on the screen, can you just explain to the jury what they're seeing?
These are images that they collected during the course of their investigation into letter, the defendant
And I guess hand signals, are those something that are synonymous with different gangs?
yes, ma'am, they are.
And each gang has their own hand signals, is that correct?
Objection, lead.
Sustain.
Regarding gangs, do all gangs have the same hand signals?
No, ma'am, they do not.
Okay, and so I guess regarding this hand signal, what was it self-identified as?
This particular hand signal identifies the gang, the Eastside Long Beach Insane Crip. This is a specific hand sign that identifies the gang.
And regarding this hand signal, what was that self-identified as?
Bloods and Crips are part of a larger universe. They're part of nations, people, and folk nation. In this particular case, he's throwing a hand sign that represents the folk nation. It's just a larger group within the group that he's representing.
And then this hand signal, what was that self-identified as?
This particular hand signal, he's identifying I guess a status within the gang, a rug rat. This is could mean a prospective member or somebody who's entering the game.
And I guess, can you just explain to the jury what this form is that they're seeing?
At the time of housing, classification officers will ask a series of questions. These are stability factor questions. These enable the classification officer to appropriately house. These questions are generally outside the gang affiliation. These are more about the individual themselves.
And then just regarding this line right here, can you explain to the jury what that is?
Yes, it's a little redundant, but it's, once again, they asked the defendant if he's a member of a gang, to which he replied that he's a member of the Crips and gave his alias or nickname.
Now regarding the photos that we just saw with the hand signals, what did you personally see when you observed those photos?
Outside the hand sign, once again, gang members are notorious for nonverbal communication. The Long Beach Insane Crip generally wear black or gray, and in almost all of those images, he's wearing a black shirt, which is another indicator of gang membership.
Okay, and are you familiar with the criminal street gang of the Crips?
Yes, ma'am, I am.
Okay, and based on your knowledge of that gang, do you have an opinion as to the purpose of the gang?
Objection, relevance.
Relevance.
Well, Judge, I mean, it goes to the reputation and character of the defendant, and
It's a different gang than what you just testified.
well, I'll re-ask the question.
All right, so that objection will be sustained.
Motion to instruct the jury to disregard the question.
All right, ladies and gentlemen, you're to disregard that last question. Denied.
All right, so as part of your employment with the Bexar County District Attorney's Office, do you keep updated with any literature that's coming up about any gangs?
Yes, ma'am, I do.
Okay, and so regarding this Long Beach Insane Crips gang, have you been able to form an opinion as to the purpose of the gang?
Yes, the gang is a criminal enterprise. That's a group that is designed or created for the sole purpose of engaging in criminal activity for the benefit of the gang.
And are you aware of any crimes specifically associated with the subset of the Crips?
With this particular one, no.
Okay. And regarding the overlying or Folk Nation Crips, what are the crimes associated with those gangs?
Yes, the Crips,
Relevance.
Overruled.
You can answer.
the Crips are a criminal enterprise. They engage in crimes ranging from narcotics all the way up to murder.
And based upon what you've reviewed in State's Exhibit P3, have you formed an opinion as to whether the defendant was a member of the Insane Long Beach Crips?
Yes, ma'am.
And what was that opinion?
He is a member of the gang.
We pass the witness, Your Honor.
Defense.
Thank you, Your Honor. You said you're primarily employed with the Bexar County District Attorney's Office, right?
Yes, sir, I am.
And so you're obviously familiar with this case and Mr. McIntyre's reason for being in court, right?
Vaguely from what I've seen on, the news and whatever.
Okay, so you haven't reviewed any of the evidence in this case?
No, sir.
So you're not giving the jury an opinion that anything about the criminal offense that we're here to talk about was done in conjunction with a criminal street gang or for because of a criminal street gang?
I don't have any of that knowledge. No, sir.
Okay. You testified a moment ago on Wadire. I just want to make clear, there are photographs of tattoos of Mr. McIntyre's in that packet that the jury has, right?
Yes, sir.
You're not saying any of those tattoos are affiliated with the Long Beach Insane Crips?
Yeah, I have no knowledge of that, sir.
Okay. As far as the hand gestures that you mentioned, you don't have any personal knowledge of seeing people throwing up those signs as being gang signs, do you?
No, I do have personal knowledge of seeing people throwing up gang signs.
I guess what I mean by that is, have you ever seen a person in real life throwing up those specific gang signs to show allegiance and affiliation to the Long Beach Insane Crips?
For the Long Beach Insane Crips, no, sir, I have not.
Okay. You indicated that the reason why you have this material is because it was self-reported by Mr. McIntyre when he was booked into the Tarrant County Jail, correct?
Yes, sir.
And that would have been in July of 2017, is that correct?
I believe so, yes, sir.
Okay, so after the date of offense in this case, right?
I don't know the offense dates. Sir.
Okay, April 23rd, 2017 would be before this information was reported, right?
Sure.
So we don't have any knowledge or any record that indicates he was an affiliate or member of this gang at the time of the offense, correct?
I'm unaware of it, sir.
Okay. You indicated that this is something that's done for all people who are being brought into the jail in Tarrant County, right?
I believe this happens in all the jails, sir.
It happens here, for example, too,
Correct.
correct?
Yes, sir.
You didn't provide any records of Bear County classification, right? Bear County just used what Tarrant County says.
And I didn't see anything from Bear County, so I would have to assume that, yes, they use what Tarrant County.
But we
says.
don't want you to assume. So you have not seen anything from Bear County, right?
Correct.
Okay. And you were talking about the nature of criminal gangs. You'd agree with me, there are criminal gangs that operate out in the free world, and there are criminal gangs that operate solely within correctional institutions, be they jails or prisons.
Yes, sir.
And sometimes those organizations span both, and sometimes they don't, right?
Yes, sir.
You don't have any specific information about how the structure of the Long Beach Insane Crips operates, do you?
I have some knowledge about it, sir.
Well, I mean, as to whether it's primarily a jail gang, primarily a prison gang, primarily a gang that operates out in the free world, you don't know much about its structure, do you?
So for this particular gang, there are two parts of it. You have the street gang, which is a Long Beach, and you have the Crips, which is a prison gang.
Okay, well,
This group is both.
let me back up. The Crips is a term that encompasses hundreds, maybe thousands of different groups of people, right?
Yes, sir.
And you're not suggesting that all of those people know each other, talk to each other, get the newsletter, right?
I'm unaware of a newsletter, sir.
Okay, and you're unaware of any other way in which there's mass communication between all of these people, correct?
No, I am aware. So it is an organized gang. They do have an organized structure and I'm talking about the Crips as a whole, not the individual subsets. And they do communicate.
Well,
We are well aware of that.
Let me just ask you this. You're aware that some groups that would call themselves Crips are actively in gangland wars with other members of the Crips, right?
Yes, sir, that's true.
So just the fact that they're both Crips doesn't mean that they're unified together, right?
Depends which ones you're talking about, sir.
But there are certainly, not all of them are on the same page, fair to say?
Sure, yes, sir.
Okay. And you're aware that there are lots of legitimate business things that individuals who identify as Crips engage in, right?
Yes, sir.
They own businesses, for example.
Oh, I'm unaware of that, sir.
Okay, you're aware that there are a lot of popular musicians and artists that identify as being members of some subsect of the Crips, right?
I've heard of that, yes, sir.
And of the Bloods, right?
Yes, sir.
Okay. Now, the Crips and the Bloods have predominantly been African-American gangs, right?
Objection relevant.
Your Honor, I think it's extremely relevant.
What's the relevance?
We're talking about jail classification and reasons why someone might jail classify other than a desire to commit criminal activity.
All right. Objection is overruled.
So the Crips and the Bloods are predominantly African-American gangs, right?
Yes, sir.
The Orejones and the Tango Blasts and Latin Kings are predominantly Hispanic gangs, right?
Yes, sir.
The Aryan Brotherhood is a white supremacist gang,
Yes, sir.
okay? So people that book into a jail, when you talked about wanting to be housed with their own people, part of that is about if they are a member of a gang, they don't want a rival gang to be where they live, right?
Correct.
But it's also to some degree about racial divide, is it not?
Depends on the gang.
I mean, an African-American probably doesn't want to classify as an Aryan Brotherhood member, right?
I would think not.
Okay, and that's about their personal protection and safety in the jail.
Sure.
Okay. Were you asked to do a review of any other individuals in association with your work in this case?
No, sir.
Okay. So you would be unaware if any other individuals that were investigated in this case are members of any criminal street gang?
Correct.
Okay. And this information, to be clear, comes from a centralized database maintained by DPS, right?
Yes, sir.
And Mr. McIntyre's entry into that database had actually fallen off, you said, correct?
Yes, sir.
Meaning that he reported it so long ago that it's no longer in the database today, correct?
Correct.
Okay. You had to go back to Tarrant County to find their records to see that that was something he said when he was first classified.
Yes, sir.
Okay. And you don't know of any corroborative work that's done by the people in Tarrant County to confirm what Mr. McIntyre or anybody else says when they self-report affiliation, right?
I don't understand that question.
So, I mean, if someone walks in and they say, I'm a member of such and such criminal street gang, right? And somebody goes, okay, well, fill out this form, check the box, I'm going to put it in the system. You don't know of any efforts that are done to go and check that out, right? It's not like, well, or do you?
Well, he housed with other members in the
Okay.
Tarrant County and he seemed to be fine over there. So I think the members corroborated the information for us.
Okay, so you think just because no incidents occurred while he was locked up with those people, that corroborates it, right?
I would think so. Yes, sir.
Okay. But it's not like someone was out there, hitting the streets in the free world, interviewing people to confirm whether or not what a man says when he's booked into the jail is actually true as far as the free world is concerned.
I'm unaware of any of that, sir.
Jails are very difficult places to be living, right?
Objection, relevant.
Overruled.
A jail is a difficult place to live, wouldn't you agree?
I would think so. Yes, sir.
You're surrounded by people who are there because they've either been accused of or convicted of breaking the law.
Yes, sir. That's true.
And so people are sometimes violent in jails,
I believe so. Yes, sir.
and there's drug use in jails.
I'm sure there is.
There are people who are trying to blackmail other people in jails.
I would think so. Yes, sir.
Well, you worked at the sheriff's office too, correct?
Yes, sir.
So you're aware that the sheriff's office has extensive training of their jailers to how to avoid being blackmailed by people who are locked up in there, right?
Yes, sir.
So you know that those kinds of con games and attempts at compromising a person happen all the time in jails.
It does happen. Yes, sir.
There's people being sexually assaulted in jails,
Objection, relevant.
Overruled.
right?
I'm sure there is. Yes, sir.
Okay. And so there are only a finite number of jailers that can watch these people, right?
Yes, sir.
And there's recording equipment and surveillance equipment in jails, but it doesn't catch every single nook and cranny of the jail, right?
Correct.
And so people often have to look out for themselves when they're locked up. You'd agree?
Yes, sir.
And that requires not doing things that will upset other people who might not be the most reasonable and rational, right?
Sure. Yes, sir.
You don't want to pick fights with somebody who's, a 6'5", 5-time serial killer, right? That wouldn't be a good idea. You'd agree?
Yes, sir.
Okay. It means that if you are trying to avoid being taken advantage of and things like that, you need to try and make relationships with other people, other inmates.
Yes, sir.
You mentioned that the name of this group is the Long Beach Insane Crips, right?
Yes, sir.
And you mentioned that as it stands in the free world, their origin is in Long Beach, California.
Yes, sir, that's true.
Okay. And you know that as groups get more prominent in different facilities in different states, different jurisdictions, there may be differences in leadership or policy or attitude between those different facilities, right?
I'm sure that's true. Yes, sir.
Okay. And you don't know anything about the president of the Long Beach Insane Crips that would be running things in Texas,
No, sir, I do not.
or any of the other officers that might be involved in that structure,
No, I do not.
or even if that's how exactly they structure their organization.
With your exact terms that you're using right now?
Well, right, I mean, when we think of an organization, we think of it as having a hierarchy, right?
Yes, sir.
But not all groups have the same kind of a hierarchy.
In organized crime, which is what the Crips are, there is an organized structure. What this particular organized structure is,
Can I object to non-responsive?
Overrule. You can answer the question.
the Crips are an organized structure. They have an organization. I think you're asking me to use your words to identify that organized structure. What I'm telling you is, I don't know who the members are that meet those particular organized ranks, but they do have them.
Okay, well, what are the ranks?
Well, you have what's called an OG or an original gangster. This is somebody who's a founding member. And then you have a youth or a youth member. This could be have different other names for them. And in between all that, you have soldiers, which are either incarcerated in prisons or out on the streets.
Okay, so you think that generally that's how all of these gangs operate?
No, sir.
Okay, you think that that's how the Crips operate?
Some Crips. Yes, sir.
Some Crips.
Correct.
As to the Long Beach Insane Crips, you don't have any specific information about members fulfilling these hierarchical roles.
No, sir, I do not.
Ask the
Sergeant Rodriguez, in Texas, is there such thing as an ex-gang member?
Yes, there is.
Okay. And if somebody was an ex-gang member, when they go to be classified, is that something that would be notated on the documentation?
Yes, ma'am, there, it would be.
Okay. And when we talk about corroboration and whether people in Tarrant County went to corroborate, I mean, the photos that you've seen, you'd agree with me, those were taken way before the defendant was ever in the Tarrant County jail,
objection to
correct?
pleading, Your
All right, with regards to leading, that would be sustained.
Honor. Motion to instruct the jury to disregard the question.
All right, ladies and gentlemen, disregard the question. Denied.
Have you had a chance to observe the photos that are contained in State's Exhibit P3?
Yes, ma'am, I have.
Okay, and specifically these photos, were those taken when the defendant was inside of the Tarrant County Jail?
No, ma'am, they were not.
Okay, and so, I mean, in your opinion, would these hand signals
No, I'm objecting to
corroborate?
personal knowledge. Which
Overruled.
which are you referring to? Sorry.
Or would you like me
Objection
to
is
put it up
overruled. You
on
can
the
ask your
screen?
question.
Just a second.
I withdraw the objection.
All right, now regarding this photo that's depicted on the overhead, is that photo taken in the Tarrant County Jail?
No, ma'am, it's not.
All right, and so would the hand signals corroborate the defendant's self-admission in your opinion?
Yes, ma'am, they would.
We pass the witness, Your Honor.
Briefly, Your Honor. You indicated that these documents and these photographs showed something about a gang sign about being a rug rat, right?
Oh, yes, sir.
Which you indicated was someone who's a prospective member of the gang, correct?
Yes, sir.
Which would mean that they're not a member of the gang at the time. They're trying to get in.
Right, correct.
You are not aware of any specific crime perpetrated on behalf of the Long Beach Insane Crips, right?
Can you rephrase that?
You don't know of any specific crimes that have been committed for or by the Long Beach Insane Crips to promote or further its enterprise?
So are you asking if I have direct personal knowledge of a specific crime committed by that group, or am I aware of the gang's involvement in criminal activity?
The first question.
I am not aware of specific crimes committed by that gang.
No further questions and excused by state.
Excuse.
All right, the rule has been invoked. You're not allowed to discuss your testimony with anyone during the pendency of this trial.
Thank you, Judge.
Thank you. All right, state, call your next witness.
State rest, Your Honor.
Now we approach.
Yes.
Thank you.
All right, ladies and gentlemen, the state has rested for this phase of the trial. What I'm going to do is I'm going to give you all your recess for today. But I don't want you all to leave the jury room just yet. I'm going to speak to both the state and the defense to see what time they would like for you all to be back tomorrow, because I don't want you to come back into the morning just for me to tell you, no, it's going to be the afternoon. So just give us a few minutes to decide that. All right. Here's my instructions. You're not allowed to do any research on this case. Again, everything that you need to know about this case during the phase of this trial is to come from inside the courtroom. You're not allowed to start deliberating internally with yourself or with each other. Just don't even think about this case unless you're inside this courtroom. Does everyone understand? All right, so if you all will wait for me in the jury room, and I will come back there as soon as possible to tell you when we'll start tomorrow. Everyone, please rise for the jurors. Right, everyone, please be seated. So, defense, if you can let me know what time, and again, if your witness needs to appear by Zoom, they can appear by Zoom.
Yes, Your Honor. Thank you so much for that accommodation. Give me a moment. I realized my phone just died, so I got to power it up so I can make these calls. One second.
All right, no problem. And while they're doing that, if y'all can collect the evidence and make sure that it's together for Sydney.
Yes, Judge.
Thank you. Just 2 seconds.
Are we gonna bring them back in?
No, I was just gonna tell them, I thought we agreed that I would just tell them back what time to come. So what time?
We got morning. We couldn't get a hold of him, but as far as I know, the morning is the time that.
All right, what time in the morning?
We shoot for maybe like, is that?
That's correct. Oh,
Oh, okay. I thought we were trying to pay attention. Sorry.
No.
Can we do, let's say, 10 o'clock?
all right. So if we're gonna do 10, we might as well shoot for 11. The reason why I'm saying that is because I have docket tomorrow. And if we just say 10, it wouldn't even give me a chance or the deputies a chance with inmates or whatever. So,
Uh,
but I tell you what, this is what we will do. I can tell the jurors to be here at 10. If your witness is not ready at 10, then he's not ready at 10.
should be 9.
My only concern is that his unavailability is due to waiting to testify that day. He said the afternoon.
No. Are you all expecting the testimony to last long?
How much?
I don't expect it to go very long, but having it cross.
But see, here's the thing. If y'all want to start this at 8:45 tomorrow, we'll be here at 8:45. We're here. If y'all want to start it at 8:30, we're here at 8:30. If you want to start it at 7:30, we're not going to be here at 7:30. But if y'all want to start it at, I'm usually here by 8. If y'all want to start this at 8:15, 8:30, I know the deputies are here at 8. If that's what time y'all want to start it, we can start it at that time. But here's the thing. If I tell this jury to be here at 8 or 8:15 or 8:30, everybody needs to be here at 8:15 or 8:30, ready to go.
Why don't we do 9 o'clock? I would like it to go in a certain order, but if it doesn't work out that way, I have someone I can call at 9 o'clock.
All right. So I will let the jurors know that we will start at 9. And Norma, if you can let the attorneys know that their cases are going to be recalled for the afternoon. And so we'll put those attorneys, let me see what our docket looks like. Just give me a second. And see who do we have in custody.
And I wasn't sure if this trial can be over today, so everybody's coming dressed.
No, that's fine. Norma, let the attorneys,
Glad we caught it.
I'm sorry, what?
Yeah.
What?
Now, the assistant of Dr. Fabian says that afternoon would be better.
All right. So, okay. So,
At 8.
all right, so this is what we'll do. I'm gonna tell the juror, what time in the afternoon? 1:30 or what?
He was not sure, to still got in contact with Dr. Fabian.
All right, so here's the thing. For me, afternoon means 12 or after 12. So I will tell the jurors to be here by 12:30. And so Deputy Laura, we can have the jurors here by 12:30 tomorrow. And they can have lunch beforehand. Tell them to make sure they bring a lunch.
You're gonna let them know?
Are you okay with the deputy letting them know?
12:30?
Yes.
Okay, give their phones and we're ready to go.
Yes. Oh, be sure to let them know that if they want to have a parking space, people usually go off campus, but they need to be here by that time. Otherwise, they may not have a space.
Okay.
All right, thanks. And then we'll keep our regular docket in the morning the way we have it, Norma. All right, is there anything else?
No, you're on.
All right, have you all made sure, one, that the court reporter gets back on her mics?
Good, Judge.
And two, right, and two, that she has all the correct exhibits.
Yes, Judge.
And then 3, that's it for today. See y'all tomorrow.
See you tomorrow.
All right, is there anything else? Hunter?
No, I don't think so. I'll just let the court know, you probably will be asking for a sudden passion instruction whenever you're, and that'll be the only such instruction I think we're asking
At least I can think of, just so it's out there.
All right, well, then, since it's gonna be afternoon, I think it'll probably be best then to do closing arguments, maybe Wednesday morning.
That's fine with us, Jeff.
All right,
The only problem
He's not
I
gonna
have
be
with that
here.
is that oral argument.
Ah.
Wake up.
all right, then we'll stay a long night.
Hopefully, we will not take up too much time with our testimony and
Okay,
Thanks,
All
Judge.
right.
get that done. Thank you.
okay, you're welcome.
Enjoy more of our videos on the Community Advocate Network channel, and don't forget to like, share, and subscribe. If you would like to advertise your service, special announcement, or event, you may contact us at the Community Advocate Network at gmail.com. For community resources or services, visit our website at www.canmichigan.com.